Your Right workshop on the topic Legal Immigration Pathways and Policy Updates. My name is Benga Gunjimi. I'm the Executive Director of the Nigerian Center, and I want to thank you for making time out of your Saturday morning to join us on this very important conversation. Just to give you an outline of what to expect today, I'm going to be talking briefly about the Nigerian Center's work, and I would introduce our partners. And our partners will introduce our speakers, and then will come our immigration attorney. Then we are going to open it up for Q&A. For the Nigerian Center, I want to play a very short video to just introduce the work that we do at the Nigerian Center.
We can't hear the audio.
Oh no. Okay, let's do it. Let's do it again. We may have to go without the audio, unfortunately. Okay, so let's move forward. Unfortunately, we can't do the audio. Go back to the presentation. Give me 1 second. Can you see the screen though?
Yes.
Yes.
Okay. And try one more time. Co-host, please feel free to let people in as we go. Can you hear the audio or still not? Actual location members of those communities walk into. Can you hear the audio? To support the American dream and American.
Hearing audio.
While the Nigerian community, no audio, but individually has prospered.
The audio works.
Oh, the audio works. Okay. I'm sorry. So let's start from the beginning. My name is Benga Gunjimi, and I'm the founder and executive director of the Nigerian Center. The Nigerian Center is the very first Nigerian American immigrant and community center. While we are called the Nigerian Center, we serve all minority and all immigrant groups in the United States. In many immigrant communities across the country and around the world, whether they're Chinese or Jewish or Latinos or even Ethiopians, there is an actual location members of those communities can walk into to support the American dream and American experience. While the Nigerian community individually has prospered, we now have an opportunity as a community to have our own Nigerian Center.
I am most excited to be a part of the Nigerian Center because we are a resource hub. And we know that while a lot of Nigerians we may know come into the country and have a connection here or there is a huge population that don't have access. I can speak to thinking about maybe 30, 40 years ago when my parents came to the country. And while my dad came to the country through education, my mom came through a lottery. And when she got here, she had to go do things the regular way. You know, she came in New York, hustled, worked at McDonald's for like 2 weeks. And from McDonald's, she started getting, other menial jobs before she was able to meet my dad. They got married, they had children. My mom didn't go back to school until she was like 40 to finally start her career. And I know that if there was something like the Nigerian Center, she could have been afforded opportunities, access information on how to go to school or how to start her own business if that's what she wanted to venture into.
I remember my uncle, I think I was like 10. He got deported. I haven't seen him in years because he can't come back in this country. If he had had the resources that the Nigerian Center offered, maybe it would be a different story.
As a pastor, and I can speak confidently for the church community, a lot of pastors struggle with the kinds of immigration challenges that their members are having. And sometimes when we pastors meet, we joke about the fact that there's this thing that is, the don't ask, don't tell kind of thing, principle that most Nigerians are engaging in. They don't tell you what they are going through. Some of them are dying in silence. By the time they speak up, sometimes it's too late. And I know that as a pastor, I could have, Nigerian Center will have come handy in helping people to know what is right, having the kind of the right information, speak to the right attorney, have right representation in court, and just to make the journey easier and smoother in the United States.
People come here from different paths, and for the same main reason is to get a better life, a better situation for their family. So there are numerous ways, numerous paths to the United States and to citizenship. So we help people with family-based immigration, employment-based immigration, asylum, refugee cases, student visas, pretty much everything that the law allows us to assist people with with the process of immigration.
Just having this center here, it's just people identified that looks just like us who we can get the resource from. I mean, this is something that even me as a grown-up young person just wanted to come. I wanted to know that it belongs here. I'm just happy that this is here. I wish that my mom and dad, they were still alive to witness this experience.
From the time my parents came from Kenya, they immigrated to New Jersey, and that's where they actually met. It took years for my mom to find employment. My dad has stayed at the same job for 25 plus years in fear of not being able to find other employment. Not even that, being able to purchase a home, it took them 25 years to buy their dream home. Having the healthcare aspect and having health insurance for my siblings and I. Nigerian Center is providing a service from all crosses across the board for immigrants.
And Nigerian Center provides opportunities with immigration and naturalization, provide home ownership opportunities, access to capital, language classes, and cultural programs.
Learning about the Nigerian Center was a godsend. Growing up, I used to think about how we can share our experiences and our culture. And oftentimes, Nigerian people are so interested in giving back, but there are few opportunities to do so. So when I heard about the Nigerian Center, it just clicked. We're talking about home ownership. We're talking about financial literacy. We're talking about immigration services, not only for people from our background diaspora, but for everybody else as well who gain from it. I see the Nigerian Center not only as an opportunity to celebrate our culture, but to also share it as well.
I welcome you to be a part of the journey and to be a part of the experience. Welcome to the Nigerian Center. Okay, thank you for the time for that. I quickly want to go through our upcoming events before I turn it to our partners. Very important. April 11, we have a community meeting. This is our own town hall family meeting. As you might have heard, Nigeria, there's a bill in Congress that is proposing to redesignate Nigeria as a country of particular concern to the United States, given the armed conflict in northern Nigeria and the persecution of religious groups. Nigeria was on that list under the previous Trump administration. It was removed under Biden administration, and Senator Chris Smith has reintroduced this legislation for Nigeria to get back on the list. It's a very sensitive, volatile topic. What we're going to do is to provide argument, opposing argument, and supporting argument, and we want to leave it to the community with their agency to engage with their elected representative. So please come to Zoom, go to Nigerian Center to register to attend this very important event on April 11th. Nigerian Center does taxes. April 15 is the deadline for filing individual taxes. If you have not yet filed your taxes, if you have back taxes, please contact the Nigerian Center. We are able to help you file for free, both in person or virtual. The requirement is you make $67,000 or less. It is a free service. Please contact the Nigerian Center. Tax compliance is sometimes become a barrier for immigration status. And just for you to live your life in America and we want to help remove that barrier, go to nigeriancenter.org/VITA to complete the form so we can help you. Immigration. We have a walk-in immigration on Thursdays. The service is also available virtually. It's a free service if you're able to come into the Nigerian Center. If you're not able to come, there's a small fee to do a virtual service or component of that service. nigeriancenter.org/immigration is where to go. How do you get involved with what we do? Volunteer opportunities are available on Nigerian Center/serve. Community partners, like the ones you have here, please complete the form online if you want to be a community partner. If you're not following us on social media, this is our social media links. And I'm speaking very fast. It's being recorded. You can go through it back again. You can join us on social media. Nigerian Center is volunteer-led run. We rely on community financial support to do. Please consider donating to the Nigerian Center today. We are 501c3. Your donation is tax deductible. I'm going to ask you can all mute. That would be great. nigeriancenter.org/donate. Also, people think that you have to give us a lot of money to make an impact. Regardless of any amount you give, $5, $10, $20, you're contributing towards the support of the community as a whole. And this is the only center we have, and we're trusting in your community support to continue to do the work that we do. That said, I'm going to turn it over to Mr. Prince Maduka of NAPAC, Nigerian American Public Affairs Committee, to speak to us about NAPA's work. And after that, Prince kindly introduce Mr. Kayode, and Mr. Kayode will introduce our wonderful speaker.
Thank you, and thank you, Mr. Gunjimi. My name is Maduka Nkuku. Good morning, everybody. I'm speaking from California, so it's good morning to you. If you're in the East Coast, good afternoon. If you're in the Central part, good morning. I am the president of Nigerian American Public Affairs Committee. Our organization was established in 2011 as a 5014C entity. And the purpose is to inform and empower Nigerian Americans in the United States through policy impact, education, health, and wellness, as well as effective advocacy and economic empowerment for our people. NAPAC operates with a 5013C entity as well. That way, people who support us get tax benefit when they do make donations to us. On the political front, we operate with what we call the 527 organizations. Through these organizations, we have been able to sponsor no less than 20 Nigerians into various political positions across the United States. And we continue to grow with that effort. Today's event is one of such advocacy activities, initiatives that we engage in. Today, we are partnered with the Nigerian Center and the Association of Nigerian Organizations, the Georgia chapter. We are hoping that the present situation in the United States will encourage people to come out and join our efforts to make sure that our community is properly represented in the various political opportunities that present themselves. It's obvious to us that the immigrant community, the diaspora community, is challenged as we have never seen before. It is our hope that the opportunities presented by these types of initiatives that we have today will give us the opportunity to share ideas, help each other to fight off the assault on our stay in this country. We have been complacent for some time. That's our observation as an organization, that Nigerians, for whatever reason, have not taken advantage of the opportunity and their rights to vote and be voted for. NAPAC has done a great job of holding the fort But now we need us to come out. We need to win more elections. We need to have our people in more positions of authority. That is the way we can protect our children. And I will say that it is a great thing that NALA, the Nigerian Association of Lawyers, and the Nigerian Center have also come together to create an immigration defense fund, which we should be launching in a couple of weeks. And this purpose of this fund is to be prepared to support Nigerians who might find themselves in legal battle over the current immigration policy changes that we're experiencing. And when we launch that event, it is our hope that you will support funding that project because it's for the benefit of our people. So with this little that I have said, I will pass the mic on to Mr. Kayode Adekunle, who is the chairperson and president of the Nigerian Association of Nigerian Associations in Georgia, who will introduce the speakers for today's event. Thank you. Mr. Kayode Adekunle, over to you.
Yeah, thank you, Prince Maduka, for that introduction. Good afternoon here from the state of Georgia, and good morning to the folks in California and elsewhere. Again, my name is Kayode Adekunle. I am the president of ANOG. Basically ANOG stands for the Alliance of Nigerian Organizations in Georgia. We've been around since 2004. So we've been, around, for a while. So real quick, we currently consist of about 40 member organizations. I'll probably say about 25 of those are very, very active. And the reason and the beauty of ANOG is that we encompasses all parts of Nigeria. All, district is covered. We, from every part of, from east, north, south, west, we have, groups within those regions. Again, like I said, we are over 40 member organizations. Our mission is very simple, right? We're here to unite and empower our community by really celebrating our real rich cultural, heritage, and basically trying to uplift our community. We have 4 main goals that we pursue. One, we're here to promote Nigerian culture. As you well know, our culture is one of the most beautiful in the entire world. When you see our outfit, when you see our art, there's no way you will not recognize these are Nigerians. We excel everywhere there's culture, we excel. That's one goal. Second goal is to improve our welfare, right? So we're here in Georgia and we all have different needs. Our goal is to improve the welfare of Nigerians in Georgia through various support programs. Third goal is to really engage our folks in civic engagement. That could be partnering with, like NAPAC for political purposes or other civic minded groups. And then the last goal, and this is very, very important, we are here, we want to support our local businesses. It could be Nigerians, it could be African businesses. We all know that the only way we can prove our use in this country is to show that we're actually contributing. So by promoting and supporting these Nigerian-owned businesses, African businesses, we are paying taxes, and we're showing, that we're actually contributing positively to the diaspora here. So I'm not going to stay for too long. What we're looking for partners. So obviously, we are grateful for the partnership that we're beginning now with NAPAC USA, also with the Nigerian Center. We believe there's more to come on this front. So like they've stated, we are all 501c3 or 501(4) endorsed. So on our website, you find a link. We're 501c3 and we need money to do what we're doing. We need money. There's no ways about it. So on anogusa.org, there's a link there. You can donate. You can support us in what we're doing. One of the things that I'm going to ask everybody we're putting together what we call an ANOG resource playbook. If you're a business, of any kind and you want to be able to help, our folks, please, contact me directly, on the chat so that we can add it to our resource and playbook. What the resource playbook really aims to do is so that when people need any kind of help, we can look in that playbook or that resource book and point them in the right direction for help. So that's what we're here for. So again, if you want to be part of our resource book, please let us know and we can add it to that resource book. Again, without taking too much time, I would like us to get into the meat of the program where we're here. I'd like to introduce, Honorable Tunde Akinyele. He has been part of our community for years and years and years. He's been a lawyer, he's been a judge, he's had so many responsibilities, both within the DeKalb County here and outside the DeKalb County. So without delay, I would like him to introduce Honorable Tunde Akinyele.
Thank you, Mr. Adekunle. Good afternoon, everyone from Georgia, and good morning, everyone from elsewhere. My name is Tunde Akinyele, and I am a judge in mostly DeKalb County in Georgia. I have been practicing for about 25 years, and I've been on the bench pro tem for approximately 11 years. And pro tem means I am a designated judge, which means that I'm still allowed to practice because I'm not a constitutional officer. Over the years, I have sat in municipal court, in traffic court, in state court, and juvenile court. I presently sit in traffic, juvenile, and in municipal court. My experiences have been both, or I've been as a prosecutor, I've been a defense lawyer, and now as a judge on the bench, which means that I bring all three perspectives to my experiences that I can share with you. When I was a prosecutor back, I think from the 2000 to about 2013, we focused on making sure that the prosecutor's job was to deal with the criminal matter that is in front of the prosecutor. The defense lawyer, on the other hand, had to focus on giving what we'll call minimal advice of rights to the person, immigration advice of rights, in addition to the criminal advice of rights. However, a major case came down from the U.S. Supreme Court back in 2010. That's called Padilla versus Kentucky. And that case essentially said that if a lawyer must advise a client about immigration rights, you have to not misadvise them. You have to give them the proper advice. Otherwise, that could be a source of claiming ineffective assistance of counsel, which is a way for having cases reversed. However, the court also said in Padilla that criminal defense lawyers are not necessarily expected to know all aspects of the law, as in they're not supposed to know what immigration practices are. And the immigration practices are different from what happens in criminal court, which in essence led to a situation where the expectation was that the criminal defense lawyer was to refer the client to an immigration lawyer, a specialist, to give them further advice if they have a situation that makes them deportable. And the cases, I think Padilla gave folks a few years to try and retroactively go through cases, but the court did not allow it to go way back, as in, I think after 2013 or 11 or 13, somewhere thereabouts, you could not go back, otherwise it would open the floodgates. So if you were given misadvice 20 years ago, it's too late. You cannot go back and claim that I was misadvised. And so the courts all over the country decided to start make the warning to the defendants in court more, I guess, more detailed. The courts over time have now come to have in the plea colloquy the fact that you will be deported. Every prosecutor knows to use that term, that do you understand by entering a plea that you will be deported, even if the outcome is not deportation, because they do not want to differentiate between cases that are deportable versus not deportable. Immigration does, okay? So immigration has what they call deportable offenses, which I'm sure the immigration lawyer that will speak will be able to advise you further of those. You have crimes involving moral turpitude. In the criminal court, those will be cases like forgeries, theft by shopliftings, theft by takings, theft by deceptions. You have crimes, what they call offenses that carry a sentence of 1 year or more makes you deportable, and that is most misdemeanors in criminal court. Most jurisdictions, your misdemeanor maximum penalty is a 12-month sentence. Immigration does not distinguish between probation or incarceration. In immigration court, even if you are placed on a 12-month probatable sentence, it is still considered incarceration because you have the risk of incarceration while you are, even though you are on probation. So any sentence, and a majority of cases in misdemeanor court will be 12-month probated sentences. So over time, those of you that may have come to court before will see lawyers asking for less than 12 months of a probated sentence. Or last for 11 months and 29 days, 11 months, 28 days. That is discretionary with the court. Some judges will allow you to have that, and some judges will not. And judges that sit on the bench also have, we take immigration classes. We have immigration lawyers come speak with us. So everyone is aware of those. The reason why a lawyer will be asking you for less than 12 months. As a matter of fact, in situations where you have a defense lawyer that comes before you on a misdemeanor case and that does not ask you for that, sometimes the judge will sua sponte, which means on their own say, you know what, even though the prosecutor is asking for 12 months, I'll just do 11 months, 29 days because I don't necessarily consider this offense to be one that should rise to the level of deportation. Now, you have offenses that the other forms of offenses that make you deportable are what they call aggravated felonies. Aggravated felony offenses are not necessarily the same definition of felonies in regular state or superior courts. You have the usual felonies, which are all aggravated felonies, the robberies, the murder cases, manslaughter, rape, child molestation. But you also have misdemeanors that could be considered aggravated felonies. So, for example, a domestic violence case that you're sentenced to 12 months or more could be considered an aggravated felony case versus even though it's a misdemeanor in state court, or it could be a felony in immigration court. You have other matters that makes you deportable in immigration court. You have things such as first offender. I think sometimes the law, you're allowed to use a first offender for offenses in criminal court. The first offender is not applicable in immigration court. So even though you're sentenced to a first offender sentence in immigration court, in criminal court, you can still be deported depending on whether your case is either a crime involving moral turpitude or an aggravated felony. The same principles apply for what we call dead dockets. Dead docket means that a case is temporarily taken off the calendar, it's removed to allow a resolution that's not a full closure. Immigration does not consider that to be a full closure. So they still consider a dead docket to be open, even though in criminal court, it's considered to be closed. One of the other areas that I've come across sitting on the bench in juvenile court, for example, is what we call special immigrant juvenile status. Those are cases I'm sure many of you on the news have heard of, what they call undocumented children or undocumented juveniles. Those cases are supposed to be determined by an immigration judge. And the way they are determined in immigration court is to first find out whether they are dependent. A dependent child is one that cannot go back to their country because they have a dependency. They've been either abandoned by their families, abandoned by the parents, or the place is just too dangerous for them to go back. Now, that is a discretionary opinion of each judge. Some judges will find that the person is not dependent. And if a judge finds the child not to be dependent, the child can be sent back to the country of origin. If a judge finds the child to be dependent, and in most cases, those children are usually, the petition is done by a relative that they already have. So if you hear that they came in undocumented, it doesn't necessarily mean that they don't know somebody. They probably have somebody here. In most cases, that is the way it's done. So that is the main thing that I do is to sit and make sure that people are advised properly of their rights, and to make sure that the lawyers and when we give the colloquy and when we do a preamble to any case, any calendar, one of the things I would advise, irrespective of what courtroom I'm in, is if you are not a United States citizen, you may want to reset your case to speak with an immigration lawyer before you decide on how you want to proceed with the cases. So most cases we do ask folks to reset their cases. We give them that opportunity. If you have, I would just let folks, because I can keep talking on and on. I have several examples, but let me just give you one example and I'll wrap up with that. I have a client that I represented as a defense lawyer, I think about 7 years ago. It was a drug trafficking case, which is considered to be an aggravated felony, a deportable offense under immigration law. And the case was dead docketed. He cooperated with the government. They helped, and he gave them a lot of information. And the expectation was that the dead docket would have closed the case. However, it's not a full closure. I got a call last week. He is in immigration detention right now because of the dead docket. And so the premise is to see whether or not we can close out the case based on his cooperation with the government. So those are the kinds of matters that we do touch upon as practitioners, as judges, and one thing that judges want to make sure that the record is perfected, because what happens is if there is a problem down the road, the case reverts back to the judge, and no judge really wants to go back and start listening to a case from 3, 4, 5 years ago because something that should have been properly done in court was not done. They'd rather not try and cure it later. They'd rather do it properly. So we all want to make sure that from the immigration perspective, the person is fully advised of their rights before they take a plea on the case. All right. Thank you all.
Wow. Thank you so much. I think my summary is that stay out of trouble. But there is no small trouble if you're an immigrant. Completely stay out of trouble. Honorable, if it's okay to stay a little bit back when we open for Q&A.
Absolutely. I'd love to.
Thank you, sir. At this point, I'm going to introduce Captain White to please come to the microphone and make the presentation. And Captain L. White is from DeKalb County, Sheriff of the DeKalb County in Georgia. Over to you, ma'am.
Can you hear me?
Yes, ma'am.
Okay. Good evening, everyone. I am Captain White. I am the commander of the Administrative Program Unit at the DeKalb County Sheriff's Office. When Judge Akinyele asked me to come on, he asked me to go over what we do at the Sheriff's Office if a person is arrested and they have an immigration detainer. I'm going to back up a little bit and let you know what actually happens when a person gets arrested. The way that immigration is notified that you're arrested is through your fingerprints. We don't make a telephone call or a special notification or anything like that. If your charge is a fingerprintable offense, then your fingerprints, once it goes through the Georgia Bureau of Investigations, it goes through the GBI, their GCIC, once it gets through there, that's when immigration know that you have been detained. Once you are detained and satisfied whatever the charge or offense was that you were arrested on, that's when immigration, I'm sorry, that's when immigration has 48 hours to come pick the person up. If they do not pick up within 48 hours, we will release the person. And it's the 48-hour exact time. At that 49th hour, that person is now released from custody. Now, what happens if a person is arrested and it's not a fingerprintable offense? We'll say a traffic light violation. Well, there's something called LESC, and it's the Law Enforcement Support Center, and it's connected to our Odyssey system. So if a person gets arrested on our Odyssey system, what will happen, it connects to immigration. The LESC contacts immigration. And again, once that charge has been satisfied, if immigration has placed a detainer on the person, that's when deportation, that particular part starts for them. Any questions?
Captain White, let me just chime in real quick. I know at some point that organizations such as yours used to have immigration officers stationed within the jails, and that was very, I guess, popular within Georgia and many other states. What was the reason why those immigration officers were removed, and do you have an expectation of them coming back at some point?
I've been speaking with immigration quite frequently now that House Bill 1105 has actually passed, and is making us really talk more about immigration and deportations, which was never a huge subject unless you are a foreign national from a place that said we must notify through the consulate. Well, at this time, because it wasn't as big as it was, there are no immigration officers inside of DeKalb County Sheriff's Office. However, I know Cobb County does have that. Are we thinking about bringing them back? Well, at this time, the agency is running pretty short on staff. They're employing more. So I really can't answer that at this time because no one knows. You're muted.
Just say thank you. Thank you, Captain White.
You're welcome.
Somebody has their hands raised.
We have SI, so I would say we are taking questions at a later stage, but if it's in particularly
Captain, that's why.
Okay, I will allow that.
Yes, Captain, thank you so much for being here. We appreciate you coming on. I would like for you to please expatiate more on the traffic stop violation, because you cut off at that point. You said something about being a traffic stop and then the LEC, and then you cut out of there.
Okay, so when we talk about traffic stops, if there's a traffic stop and there's a DUI involved, of course, DUI is fingerprintable, meaning it's going to be part of your criminal history. But if you have a traffic stop where there's a red light violation, failure to yield, that will not be a fingerprintable offense. So it will not be a part of a criminal history. So that was the difference in the type of traffic stops. When it's fingerprintable, automatically it goes directly to immigration, because anytime you're fingerprinted, they're going to know. If it's not a fingerprintable offense, it is done through LESC, but by the time that LESC goes through that portion, and usually you're out within minutes or that day, they will know. However, if there's no other charges other than the traffic stop, then immigration usually is not involved.
Follow-up question: what about a probable cause? All these probable cause conversation that they usually stop for. The probable cause thing,
right? Lately, I haven't seen any come through DeKalb. I know it's possible. I know that they can, where they just make the arrest, and the arrest is just for immigration purposes. It has been placed into law where they can do that. I haven't had any come through the DeKalb County Sheriff's Office, but at that time, yes, you're going to be fingerprinted, and with that, immigration is immediately notified when that's the situation.
Thank you so much, Captain. Thank you very much.
You're welcome.
And Captain White, in Washington, D.C., I don't know, Georgia, we have this limited purpose driver's license for those who are still in the journey of immigration to be able to drive. And folks get concerned about using that identification. Do you have in Georgia, is there an obligation as a law enforcement when someone shows such an ID to be referred to ICE? Should they be worried driving with the limited purpose driver's license or no?
I really can't answer that. Honestly, I don't work the street at all. I work inside of the jail facility once the arrest has been made. Because of how the law is being interpreted and then what I'm understanding, and of course, we're still meeting about these things. We even have meetings downtown at the federal building on what's taking place, even with passports. Next week, I will be meeting at the federal building because they're going to go over things such as identification purposes. So we haven't even met on that yet, but we will be meeting on that next week. And I can give Judge Akinyele more information about what we're meeting on. I don't know if he got the invite to go, but I know that the law enforcement heads, we are going to meet on that next week.
Thank you. And I will also turn it over to Judge. In your office, because driving is usually one of the major ways in which people get into deportation proceedings. Sir, is driving on with a limited credential, a driver's license, particularly in this climate, is this something folks should be worried about or no?
Not in Georgia. We don't have, well, first, we don't have a limited purpose driver's license. Georgia, you either have a Georgia driver's license or you are considered to be unlicensed by law. If you reside in Georgia and you've resided here for more than 30 days and you intend to stay. So what happens is some folks from other states that give non-immigrants licenses, such as DC, North Carolina, the folks will drive in Georgia. They can still be charged with driving without a license and still be arrested for those offenses. But the purpose will not be for immigration purposes. The purpose will be for violating the Georgia license statute. So that is what happens in Georgia. Georgia officers are not, even though the state just signed a new bill that says that if immigration places a detainer on somebody, that it is the responsibility of that agency to hold the person for immigration. But as Captain White said, they are still following the rules. The United States Code is still the 48-hour rule that they have to pick them up within 48 hours. Otherwise, they release them. But the short answer is no, they are not running licenses just for purposes of immigration in Georgia.
Thank you very much. So I'm going to ask Captain White also if you can please stay behind. We'll have a segment for Q&A. In addition to Honorable Judge, that would be wonderful. At this point, I'm going to bring in our rep from Pennsylvania, our wonderful Honorable Rep Carol Kazim from the state of Pennsylvania, to talk about our office's interaction with immigrant resources that may be available. And from a state policy standpoint, what are you seeing that folks should be aware of, Honorable Kazim?
Sure. Thank you so much, Benga. I appreciate everyone for joining, and thank you so much for having me. I just want to do a tech check. Can you all hear me?
Yes, we can.
All right. Thank you so much. So my name is Carol Kazim. I'm a member as well of NAPAC. I'm familiar with the Nigerian Center out in D.C., although I am in the state of Pennsylvania. I'm more in the East Coast, but I do collaborate and work with other officials across different parts of the state. So I just want to talk a little bit to you guys that even though I am in Pennsylvania, for those that are in PA, we're not too much different from as part as Georgia and the way things are running. However, there is some difference on the way that we're providing support and some of the legislations and some of the rules that is taking place in Pennsylvania. I have been talking to different officials as well across different states, especially on the East Coast, about some of the rules and things that we're putting in place or things that I've been providing to our communities. So the first thing that I did wanted to provide, as a legislator, what I'm realizing is that even though immigration is on the federal side, I realize that there's still some conflicts when it comes to information. I feel like there's always an open-ended question on, well, what if? And a lot of times that's where we bring in the attorneys and sometimes the immigration lawyers also may realize that there are things that were different versus what was provided to them in the past, based off of what some judges are looking at as the law, based off of what legislators might put in that's in place. Even though, again, immigration is on the federal side, the state does have the authority to provide certain ordinances. I'm sorry, someone's off of mute. The states do have the authority to also put certain legislations in place that can also impose whether it's penalties or even just stop certain processes, or may provide a slower process for ICE in the state. And that's where sometimes it can get tricky in the courts. So the first thing that we have here in Pennsylvania, and I'm very adamant about, and I made sure that most of my colleagues know this, and I talk to a lot of police departments, is that here in Pennsylvania, our officers are not allowed to ask your immigration status. That's first and foremost. A lot of people believe that that's something they can do because they're officers. An immigration agent can ask you, but not a police officer from any of the local police departments. They are not allowed here in the state of Pennsylvania to ask you your immigration status, and I believe there are many states that are ran the same way. So you do not have to provide it, but if they do ask you for your name, your ID, and so forth, yes, you have to provide that information. Your immigration status does not have to be provided unless it's an agent from the immigration appropriate department. The second thing is, I do know that there are many people that are calling ICE or reporting, because that was something like a trend where they started that, oh, if you call, you'll get some money and so forth. So I know that they did that a lot here in my state, in my area, they did it a lot. But what I had to do was I had to go, because first and foremost, another information that is not put out. If the immigration agent does come to your door and knock and do not have a warrant, a judicial warrant, you do not have to answer the door. That's first and foremost. In order for them to say that they are taking you, and honestly, I don't know if many people know, some people may disagree, but that's really something across the whole United States that is not being put out. And I know that because it's in there in the law. You must have a judicial warrant, and it has to be signed by a judicial judge. Now, what I'm seeing is a lot of different warrants are signed by individuals that are not, and they're just accepting it. But that's not how it's supposed to go. A judicial judge has to sign the judicial warrant in order for them to pick up or detain that individual that they are looking for. Now, the individual is arrested by the local police department and their fingerprints are ran, just like the captain stated. They can run your fingerprints, and if they do show that they are looking for you or ICE is looking for you, they must be contacted. And they usually hold them for 48 hours. If ICE do not come, then they can release you as long as the local police department is not holding you. That's the third thing. As far as the application process, there are many people that applied for green cards or certain visas. And I do know I've gotten calls in my office where their applications are been moving slowly, or they were almost at the final step and they haven't heard anything from the embassy. They haven't been getting any word. I do know that that is an issue that is going on. And I believe that even though people are still following the legal way that our president and many other individuals are saying that people should follow, I am finding that many people applications are either being paused, or it's just moving slower, or they're not hearing back. So what I will say is I'm going to encourage everyone that if you're in that situation, or if you have not heard back on a status, or you're concerned about your status, and you're not hearing back from those individuals that you're supposed to reach out to, contact your local Congress office. That's who work on the federal side. They have the access to put in a ticket about your application and connect with the appropriate departments to see the status and to see how they can be able to help your application move forward. Now, just so you know, the Congress offices across the United States are overwhelmed with a lot of these type of requests, but there are a lot that are processing those tickets and making sure that applications are still being processed, effectively and in a timely manner. So I know that's something that I've been working on with my Congress office. And like I said, even though I'm on the state side, I've been taking in application numbers, I've been taking in contact information, and I've been working with the Congress office to figure out how we can help these individuals in their status and make sure that applications are still being processed. Because what I'm seeing is people are still being picked up. So even if they're on a working visa, even if they have a green card, even if their stuff is almost done, even if they're married to a U.S. citizen, they're still coming and they went through all the legal steps. They're still finding ways to come and pick them up, which is why I'm just stressing again about them making sure that they understand that a judicial warrant must be presented if they stated that they are coming to pick up this individual. And one of the other information, I'm sorry, I'm only looking down because I wrote down some notes. Legislation. One of the things that we've been pushing for in Pennsylvania, and I know that it's been a back and forth because we are a divided legislator. Our Senate is predominantly Republicans, our House are majority Democrats. But one of the things we are talking about, and I think it's only useful because some police departments are also overwhelmed, is making sure that our police departments were put in legislations in place that they know that they are not to provide ICE duties. So they must know and understand that their duties and immigration officers are completely separate from the duties and the tasks that they are supposed to do. This would just help make sure that police officers are doing the right thing, and it's to make sure that they're not overstepping their boundaries and just basically not making things more complicated for a citizen that's just walking down the street. I know that there are some states where they're allowing police officers to just talk to anyone, check them, ask them stuff. And because people are unaware, people don't know, they don't really say much or they just give themselves up. So we're just making sure that our police departments understand that you cannot interfere. You do not have the right to question them, and that any duties that fall under immigration officers besides what you are conducted to do when an individual is detained, if ICE is looking for them, there's nothing else that they are supposed to do in the scope of the immigration duties. Resources are also provided to the communities, and I will attach a file bank. I'll put a file in once I'm done where people can connect. So even though these resources are in Pennsylvania, you guys are still more than welcome to reach out to any of these resources. A lot of them work with many other organizations across the United States, and a lot of them are also national chapters. So even if it says Pennsylvania, I'm sure that they have chapters more than likely in your state or your neighboring state. So you can connect with them and ask them some information or see if there's a way that they connect you with the right appropriate individual or organization if they cannot help you directly. So again, I will put that information in the chat. And lastly, we are currently still working on legislation. Well, I would say for me and another individual, he is Dominican. We're both working on legislation such as the International Doctor Bill. I know that we had a teacher certification that we slowed down on. But right now, just so you know, in the state of Pennsylvania, we unexpectedly just flipped a Senate seat for the first time since 1979. So what that does is we now only have 2 seats down to that were, or when I say were, I'm going to say Democrats, it's not a political thing here, but just so you guys know, it can flip it. So what's happening is that now the other party is realizing that individuals, even from their own party, may not like some of the things that they're seeing on a national or federal level. So it's putting other individuals in seats that they may not expect to be in a seat. So what I plan on doing is using these legislations as a tool for them to say is either we're going to push forward for these specific legislations or you too are also going to be met with a lot of consequences for your seat. So one of those bills is the International Doctor Bill. I know there's many students, people that are practicing medicine, and even doctors that have already practiced back in their home country and maybe came over to finish studying. The goal is to open up the door for many that already are doctors, that have received their degree back in their home country. Or if they're currently in school and they have to do more residency or second residency program just for them to be able to obtain it so they can practice, we're just trying to open the door so they can be able to do that in the state of Pennsylvania. And with healthcare being on the highest topic right now, and we're dealing with healthcare disparities, especially in my state where many hospitals are shutting down, it's happening majority in the areas where they're filled with minorities. So I'm really pushing for this because there are many physicians who've told me that they do need doctors. And one of the things that I've been highlighting is cultural competence. And if we can have individuals that represent many communities, I feel like this will open up so many doors for people who may only still have their student visa or working visa, where we could just open up this door so people can immediately be recognized as United States citizens and be able to start practicing and have a job here. So, I mean, I'm hearing on the national side, these are the type of individuals that they're looking for. I think if we can open up this door, you know, we can open up the door for lawyers and everyone else. But at least because we know that healthcare is a major concern and we have doctors that are available and ready, they just need that doorway. They just need the opportunity. I feel like that's something that we can push. So I'm really trying to stress to my governor. He thinks it's a great idea. And I'm talking to him about talking to the Senate about why this is a good idea. So I've had some pushback, but I've had doctors tell me that they believe it's needed. I know with the World Cup going to be happening in my area, they were already asking if we can put a legislation that would allow doctors overseas to come in to provide medical support to maybe the players or other individuals, because the amount of people and traffic and tourism that is going to transpire. So I'm hoping that I can add this in with this bill as a package before voting for it. So I just want some of you guys to understand that these are some of the things that we're trying to do on the state end that would at least help individuals that are still being faced with the status and application process. So Benga, I'm going to put the file in the chat just so people will have, it's called Immigration Resources. They'll be able to see different ones in PA, but they can always call and check and see if there's another chapter in their state or if they can still assist them as well.
Excellent. Thank you so much, Honorable. So just to highlight, so this bill that you're championing, if I had my education as a doctor overseas, I may be able to transfer that to work in Pennsylvania when it becomes the law.
Correct. And I do believe that what they're probably going to do is, because I know the Senate, I know who I'm working with and who I'm dealing with, and they don't look like us. So I know who I'm dealing with. What they're probably going to do is they're going to want me to add some stipulation in place. And what I was thinking about doing already as an amendment was maybe adding that individuals that come over that probably are coming to do residency program or study medicine or already in school, I was going to probably put in that maybe they could do 1 year. Instead of the full 3 or 5, maybe just 1 year or up to 6, 12 months of certificate or something that would just make individuals feel comfortable that, okay, as long as they study here, we're comfortable in that they know our process and our laws and our regulations. So I was willing to add that in just to make them feel more at ease. And I think it is important to have that, but through a whole school thing. So that's what I'm trying to think about as far as an amendment, but yes, that would help those individuals.
Excellent. Thank you so much, Honorable Kazim. If it's possible to stay back, but if not, we would also share your information sources with the rest of the group. Please hold questions.
I'll stay back.
Okay, great. We started this train in Washington, D.C. We went to California. We stayed a little bit in Georgia, and then we came to Pennsylvania. Now we're going back to Georgia, but by the way of Washington, D.C. It's my honor to introduce Nigerian Center attorney, Miss April Holloway from Georgia, body of Washington, D.C. Over to you, April.
All right, so we're going to do 2 different things. We're going to talk about removal versus expedited removal, and we're going to talk about pathways to residency. So first, let me just pull up this PowerPoint for you to look at. All right, Benga, am I sharing appropriately? Can everybody see the screen?
Yes.
All right, perfect. Thank you, SI. All right, so removal proceedings is what immigration court is called. So immigration court can be referred to as EOIR, the Executive Office of Immigration Review, or removal proceedings. Immigration court is different from your traditional courts because it's not independent authority like your Court of Appeals or Supreme Court. It actually falls underneath the Department of Justice. Our judges are not independent, unfortunately. Now, expedited removal means that you have fewer chances for having a lawyer, having bail or bond, or appearing in front of a judge. Why is that? Because expedited removal means that you are placed in proceedings where you have to establish that you have some kind of fear of return to your country, that you're going to be harmed, that you're going to be tortured, or else you're going to be removed. And it happens very quickly. Who gets placed in expedited removal? If you cannot prove that you've been in the United States for at least 2 years, hang on for me, I'm stuck here. Yeah, okay. If you can't prove that you've been in the United States for at least 2 years, then you are at risk of being placed in expedited removal. So a good thing to do is to always have some proof either in your email, with a close friend, or on your body that you've been in the United States over 2 years, so you don't accidentally get placed in expedited removal if you are detained. That proof can be school records, medical records, it could be receipts, anything, mail that comes in your name, utility bills, anything that proves that you've been in the United States for over 2 years. And then that way you would be placed in regular removal proceedings instead. However, if you can't prove that you've been in the US for over 2 years and you do go into expedited removal, there's only one way to get out of it. That is called a credible fear interview or a reasonable fear interview. It's a credible fear interview if this is your first entry into the United States. It's a reasonable fear interview if it is your second or other entry into the United States. The difference is how high the standard is of what you have to prove, how heavy the fear is that you have to prove. It's lower for credible fear and higher for reasonable fear. What does that mean? You have to basically lay out that you meet the 5 requirements for asylum. And then if you can do that, then they'll move you from expedited removal to regular removal proceedings. What are the 5 elements for asylum? Number 1, that you've been persecuted in your home country, that you've been harmed in your home country. Number 2, that you have a fear that you will be harmed again if you return to that home country. Number 3 is the most difficult, because you can have been harmed in your home country and you can't have a fear that you're going to be harmed in your home country. But number 3 says that those 2 fears, the reason why you were harmed before and you would be harmed in the future, has to be related to a particular ground. Your political expression, your religious expression, your sexuality, your gender. It has to be tied to something specific about you that you were targeted for, not just general crime or general strife in your country, even a war-torn country. It has to be related to something that you personally were being persecuted for. Number 4, that it's impossible for you to relocate somewhere else within your own country. And number 5, that the police or prosecutors in your home country, the government of your home country, is not willing to assist you. Okay? So once you establish those 5 elements of the asylum case, then you can be moved from expedited removal to regular removal, and that is when you will have a chance to bond out of being detained. I want to say something. I want to talk about something that Captain Crystal referenced. Do I have the name? Yeah, Captain Crystal referenced about the 48-hour hold. This is what I tell people. This is advice that nobody likes to hear, by the way. This is what I tell people. If you get detained on a criminal violation, okay, and you know that you're undocumented, you're going to have an ICE detainer, do not bond out on that criminal violation. Because if you bond out on that criminal violation, you're just going to go into immigration custody with an open charge. And when you go into immigration custody with an open charge, it is truth. Okay, you do not have a chance to defend yourself against whatever that charge is. You are guilty of that charge. And so if it is a particularly serious crime, or if it is a crime of moral turpitude, one that prevents you from being able to stay in the United States despite what your asylum case is, despite that you have a US citizen spouse that's petitioning for you, then you're going to be removed. So the advice nobody likes to hear is stay in jail until your case is completed. All right. Also, I want to touch on this that Captain Crystal and also Ms. Carroll touched on, Ms. Kazim touched on, is the arrest warrant. This is not an arrest warrant. This is a notice to appear. This is the notice to appear that was presented to Mahmoud Khalil when he was detained by the ICE officers who presented no badges or identification of who they were. And they presented outside of proper uniform, and in unmarked vehicles. They did not have the authority to arrest him under this notice to appear. This notice, as you can see, is just stating at the very bottom, you can see, we're asking you to appear in court on this date. Okay, so if you are confronted with ICE and they present you with this document just says you need to appear in immigration court. Okay, so now if it says arrest warrant and it's signed by a judge at the bottom, that's different. But this document is a notice to appear. And there's a lot of problems with this notice to appear, but I'm going to skip them because we need to move on for time. But if you're interested, I will talk all day long in other forums about all the problems with what's happening with Mr. Khalil. So now we're going to move on to part 2, pathways to residency. So if you are in the United States and you're undocumented, these are some of the pathways to residency that you may be eligible for, okay? Mr. Akinyele touched on special immigrant juvenile status earlier. We're going to go through that in more detail in just a second. Asylum, spousal visa or marriage, VAWA, which is Violence Against Women's Act, which is available not just for women, but also for men, also for children who are abused by their USC parent, and also parents who are abused by their USC children. The next is family petitions. Some family petitions you're able to do completely in the United States. Some will require you to leave the United States for some period of time to finish that process. U visa, being a victim of certain crimes. A T visa, which is being a victim of trafficking. It's not just sex trafficking, it's also labor trafficking. We'll talk about that in more detail in a second. And then cancellation of removal, which is only available if you're in immigration court. So let's go ahead and do some more in-depth talk about special immigrant juvenile status. This is a 3-part process. The first part starts in state family court. Okay, so that means if you're in Pennsylvania, then it's a Pennsylvania family court. If you're in Georgia, it's a Georgia family court. Okay, that state court has to make a determination of whether or not you have been abandoned, abused, or neglected by one or both of your parents. If they make that determination, then they find you dependent on the court and that you have to stay for your safety. You have to stay within the jurisdiction of that court, and they'll issue you what is called a predicate order. When you have that order, you can then take that to immigration, to USCIS, and ask to be issued a designation as a special immigrant juvenile. With that designation, you can also obtain a work permit. And then after a waiting period, you can also apply for residency, which is the same thing as applying for a green card. Okay. The problem that we see in the community sometimes with this is that sometimes children or the families at large do not want to make a case against a family member that they have abandoned, abused, or neglected their child. Okay. So it doesn't always have to be a negative thing. If the parent simply is unable to take care of that child, or the parent is not in the United States, that's abandonment, that's neglect. It's not a moral judgment against that person. And that's a cultural thing that some people have a hard time getting over for the child to be able to pursue special immigrant juvenile status. Now, depending on which state you're in, the age that you can do this is either going to be 18 and under or 21 and under. For example, in Maryland, it goes all the way up to 21. In Virginia, it stops at 18. So that is dependent on your state court. However, for immigration purposes, that I-360 must be turned in before the person turns 21 years old, or at least mailed before they turn 21 years old. All right. Now, I gave you earlier the elements that are required to establish an asylum case. So here I want to talk about 2 different things. One is the 1-year filing deadline. There is a presumption in asylum that if you don't file within 1 year, that you don't have a valid case, but there are exceptions to that. So for example, if you initially came to the United States on a student visa and you did plan on going back to your home country, but while you were gone, your family suffered some targeted persecution or something about the category that you belong to suffered persecution, like a law was passed in your home country that you can be jailed if you're homosexual, that didn't exist when you first arrived in the United States, then you can still apply even well outside of the 1-year filing deadline based on changed circumstances. So that's an exception. The other exception is exceptional circumstances. So if you were unable to file within that first year because you had extreme post-traumatic stress syndrome, because you were in a very bad abusive relationship, because you were a child, and only until you became an adult did you realize that you were undocumented. Those are exceptional circumstances that would prevent one from having filed within the 1 year and would excuse it. The other thing is called circumvention of lawful pathways. This is something that was passed in the last administration in 2023 when there was a new app that was created called CBP1. And people were being asked to schedule an appointment on CBP1 before approaching the border, and they would be given an opportunity to establish that they were seeking asylum and given parole to enter the country. The punishment for not doing that is that you will be denied your asylum case if you do not prove that you had a valid reason for failing to use CBP1 to enter the United States. So what's happening now is I will have cases that are very good asylum cases. They meet all of the 5 requirements to be granted asylum. But if they did not use CBP1 to enter, or they don't have a good excuse for why they failed to use CBP1, a good excuse being it wasn't available in my language, the application didn't work, and I explained that to the officer when I approached the border, or I was having a major medical emergency while I was in Mexico, so I had no choice but to try and go ahead and enter, then their asylum case will be denied. Now, they still remain eligible for withholding of removal or protection under the Convention Against Torture, which allows them to remain in the United States, but that does not allow them to obtain residency. It does not allow them to petition for their family members, does not allow them to travel. Circumvention of lawful pathways is currently set to end May 11, 2025. A lot of us immigration attorneys have been arguing against CLP because the CBP1 app no longer exists. So far, judges have not accepted that argument in cases where CBP1 app was available, but that's where that currently stands. All right, so for VAWA, I mentioned that this is an application you can file if you are married to a US citizen or a lawful permanent resident who is abusive to you. So I want to note that abuse includes financial abuse and cultural abuse, not just physical abuse. Also, the abuse standard is the one here in the United States, not the one from your home country. So something being acceptable in your home country does not make it acceptable here. So if it qualifies as abuse here in the United States, then it is a basis under which you can seek VAWA. Okay, that's something that people don't always understand about this application. It also goes both ways. A lot of times what we see from men coming in is that they have a spouse who, once they get into an argument, the spouse might demand, you give me $1,000 or else I'm going to call immigration on you. You give me $2,000 or I'm going to call immigration on you. That's financial abuse. That person never has to lay a hand on you to abuse you for you to be eligible for VAWA. The other thing that people don't realize sometimes is that VAWA also applies, because the way it's named, it also applies to children who are abused by their US citizen parent or parents who are being abused by their US citizen child. Okay? All right, let's move on to a U visa. A U visa is for people who are in the United States who have been the victims of certain criminal activity. So some of those crimes are blackmail, domestic violence, stalking, rape, or attempt of any of those, felony assault. So if you're a victim of any of those particular crimes, you may be eligible for a U visa. However, you must be willing to cooperate with the police or the prosecutors. So if the police come out to your house on a domestic violence call and you tell them everything's okay, I don't want to file a report, then you're not able to come to me and say, I want to file for a U visa. The police will deny it. They won't sign off on it. They'll say she didn't cooperate when we came out to her house, or he didn't cooperate when we came out to the house, so we're not signing off on it. It is completely in their discretion to decide whether to sign off on it or not. So even if you cooperated with them 3 times out of 4 times, they can still say, no, we're not going to sign off because she didn't cooperate the entire time. She provided her statement, but she didn't show up to court. We're not signing off on it. So you have to be willing to cooperate with them the entire way. A T visa, classically, what people think of is somebody who comes to the United States and they're required to exchange sex to pay off a certain amount of debt for how much it was for them to be brought to the United States. But the more common scenario is somebody is brought to the United States as a helper of some sort. They're brought to be a nanny, they're brought to be a house worker, and then their passport is taken away from them and they don't have freedom to leave that job. They're not really being paid. They're being told, oh, you're being paid in a place to stay or by being given food. Those are trafficking incidents. Another thing that we see is children who come to the United States and instead of being able to go to school, they're expected to take care of younger siblings or younger cousins. That's trafficking. Okay, so if you're willing to cooperate with police and prosecutors on that, then you could obtain a T visa. Both of these visas leads to residency. Oh, one more scenario I forgot to mention. If you're brought to the United States by a company that says that they have a job for you, and then once you arrive in the United States, they're like, oh no, we don't have a job for you, and they required you to pay money in order to come to the United States, that's also trafficking. Okay, and the last one is cancellation of removal. A lot of people refer to this as the 10-year law. This is something that is only available if you have already been asked to appear in immigration court. So unfortunately, you can have the 10 years of physical presence, but if you're not currently in active court proceedings, you cannot apply for it. We have made, among the different associations that I belong to, we've asked for years that this application be available for people to apply for directly with USCIS, not only in court. We haven't had any success with that. So if any of the Congress people on the panel would like to take that up, there's a lot of people in the US who would be eligible to obtain residency through this method if it was only available outside of immigration court. So you have to have 10 years of proof of your physical presence. So those can be receipts, medical records, school records, utility bills, memberships with CVS or Sam's Club, anything to prove that you've been in the US for at least 10 years. The second one is that you have to show a hardship to your US citizen parent or resident parent or US citizen child or resident child. What they mean by that, the way that's been interpreted, is that there is some medical condition or educational condition that your parent or child has that they would suffer if you were not in the US to continue their support of them, or if they had to travel to the home country with you. That's how it's classically been interpreted. However, I have also been able to win cancellation cases if we can show that the child is exceptional. So if that child is in honors classes and they have been invited to compete in international, national competitions, if that child is scoring off the charts on their SAT or other exams, I have been able to get judges to deem this as a hardship as well, because the child would be deprived of the parent that provides the support for them to be able to have those high achievements. And they wouldn't have access to that if they were required to return to the home country. Okay, and the last one is good moral character. So if you have some criminal history, you can still meet good moral character if it is a resolved case, if you are willing to testify honestly and forthcoming about whatever those charges were, and if the judge senses that you've done anything to try and redeem yourself since the time of that criminal activity. The ones that I've had mostly in court are going to be assault charges and DUI. And I've been able to put together packages showing that this person has done volunteer activities. They attended all of their anger management classes. They attended their driving classes. They paid their taxes and other things to show contrition and that they do have good moral character. All right. So everything that I just talked about, you can find on the Nigerian Center YouTube page. We've done much longer in-depth series on those, particularly the one on asylum. I go through each element and give examples of what kind of evidence you can provide to establish each evidence. So the Nigerian Center also offers free consultations. If you don't know if you're eligible for anything immigration-wise, you can schedule a consultation with us to discuss that. If you're applying on your own for some relief, you're submitting your own asylum application, you're submitting your own TPS application, we can review those. We do not fill them out for you, but we can review them. If you are scheduled for your citizenship interview or you're scheduled for a spousal interview, we can have a session where we help prepare you for those interviews. If you want evidence to submit with your asylum application that is specific to Nigeria about the country conditions going on, you can find those on the Nigerian Center website. And as I mentioned, the previously recorded seminars that we've done on student relief, TPS, VAWA, particularly in that session, I talked a lot about VAWA for men. You can find those sessions on the Nigerian Center website as well. So I'm going to stop share so that we can take the questions.
Well, thank you so much. There are some questions I had, but you already answered them while you were speaking. But quick one, in terms of, I didn't think you after that, affirmatively requesting for credible fair interview. That was something that was referenced, that it's the responsibility on you to request it. Can you speak on that?
Yes. So if you are in the United States and you have never been asked to appear in immigration proceedings, but you're going to ICE appointments, that is a good situation where you want to affirmatively request your credible fear interview. Because you want to go ahead and get out in front of them, potentially detaining you at one of your ICE visits by saying, I've requested my CFI and it has not been afforded to me yet. So what more can I do? So that's a situation where you want to affirmatively request to have that interview.
Thank you. By the way, it's Captain White, not Crystal.
I'm so sorry. I'm so sorry. I apologize.
Okay. Captain White, if you're still around, can you speak to like how your office works with folks to establish that they are victim of crimes? Because we've seen situations where there may be a witness to a crime, but not necessarily the victim. If you can give those distinction and just speak about that process.
Okay, our office, being the sheriff's office, we do have a victims crime unit that works with different things, but mostly that will be done through what's called the DA's office and their investigators. That's when it really branches out to assist people on whatever crime that someone's been accused of or whoever the victim is. And in our agency, we mostly work off a warrant for someone's arrest, or when PD or whatever police department brings in a person in custody. Once they're in custody, that's when our work really starts, once a person is in custody. But having programs and advocacy programs, we don't have many at this time, but we are working on it.
Thank you. If you have questions, you can put up your hands and I'll unmute you, or you can chat in your question in the chat box. There's a question here for you in the chat box, April.
How can the Nigerian Center support a Nigerian who has a pending EB-2 national interest waiver over 6 months for premium processing? So there are two different things that can be done. One is to file an inquiry directly with USCIS on the status of it. The second thing would be to file an ombudsman request to review it. Those are the two things that can be done with USCIS. If you do not get an answer from one of those two methods, you can then go to one of your Congress people. If they are immigrant friendly, they will step in to try and get answers from you. It is important to know that when you take these steps, you are not requesting an approval. You have no control over whether it's going to be an approval or not. You're just asking them to hurry up and give you a decision. So if that decision is negative, you have to be prepared for that to be given, since you're asking for it to be expedited.
Thank you. Please chat in your questions, or you can put up your hands.
And let me also add to follow up with Captain White. It's usually the police department or the DA's office or the prosecutorial office that will do the U visa certification, as she referenced to. The sheriff's office serves warrants and detains people, so they ordinarily would not handle a matter like that. But the DeKalb County Police Department does that all the time, as well as the different DA's offices. All police agencies in Georgia are familiar with U visa certifications, so they are the ones that will do those.
Thank you. And Attorney April, witnessing a crime usually comes with psychological burdens, or would that be considered a victim of crime?
They can most definitely submit the documents to see if USCIS will approve it. The situations that I have handled, the witness has also been subject to some physical harm in addition to psychological damage. So the bullet grazed their car or grazed their ear, those kind of situations. They're not the direct victim. They weren't the intended victim, but they're still listed as a victim witness in the police report.
Thank you. Joyce, you may unmute yourself.
Yes, thank you. My half brother was into deportation over 30 years ago. He did not show, and rather than get an attorney, he moved. He moved from Illinois. He moved to the East Coast, and everything was fine. He didn't tell us anything. One day he was just picked up. He was then released. We got an attorney, and since then, he's been going every year. We've paid the attorney over $20,000, but every year he just keeps reporting to ICE. Is there anything that can be done? He's been here now for over 40 years. All his siblings are in the United States. He does not know anyone in Nigeria.
So I would not have enough detail in order to sufficiently answer your question. I don't know what petition he filed with the court, what the status is of his case with the court. So that is a case where perhaps you want to ask him to schedule a consultation so we can give him a second opinion. But just based on the facts that you gave, I have no idea.
Thank you. We'll do that.
Can I ask Ms. Holloway a question, please? I guess there's been a new communique going around about asylum cases as to avoid filing them now because it's the potential of expedited removal comes into play, as in there is a shortened period of time now. After the credible fear interview, within 40-something days, you will be removed. And I think there is also a target of law firms that are filing what they call bogus asylum claims, which traditionally a lot of people file those just to obtain work permits. What is, I guess, your recommendation as it relates to that, as far as because we do know that not every asylum case is an asylum case. People file it for the purpose of staying once they arrive. So what do you suggest with respect to what's going on nowadays?
I'm not going to concede that some people just file for asylum for a work permit. I would say that your risk of being detained as a completely undocumented person, as opposed to a person who has filed an application that is pending, is the same. However, only one of those people would have documentation to show I have taken an affirmative step to try and make some resolution of my immigration status. That's the advice that I would give someone who's asking me, should I go ahead and file for asylum or not? I'd also have a discussion with them on the strength of their asylum case. So all asylum cases may not have the same strength, and that may change how they want to proceed or if they have any other options available.
Thank you for that, April. There's I would say regular, just the social media trend now with green card holders, visa holders having problems coming into the United States and searching of phones and things like that. Can you speak to that? And is that true? How can folks protect themselves and things like that?
I've only heard one account that I believe from someone that I actually know who was traveling, and I'll be traveling at the end of next month, so I'll tell you what happens when I come back in. I do think that it's smart to be prepared. So be prepared to get to the airport much earlier than your departure in case you have any issues getting through immigration. If you are a resident, it is smart to go ahead and have a G28. A G28 is a notice of representation with your attorney's name on it, so that if they begin to ask you questions that are outside of the normal course of, do you have any produce you're bringing with you? How much money are you bringing with you? Outside of the normal course of Customs and Border Patrol questions, then you can just say, I think we need to call my attorney now. Here's my G28. But beyond that, like I said, I think a lot of these accounts have been blown out of proportion. They're people looking for views or looking for attention. I've only had one person to tell me that I know that's credible, that they had some issues. And that person did have a complicated immigration history. So it made sense to me that they would go into secondary screening.
Oh, that is so insightful. You do have some other questions in the comment?
What if someone not wanted by ICE? Oh, okay. What if someone not wanted by ICE commits a traffic offense? Do officers notify ICE of him or her? This is the same thing that Captain White, not Captain Crystal, that Captain White spoke to earlier. So if they have any reason to run your fingerprints, there is an automatic notification that goes to immigration. But if they don't, then they won't. For the most part, like if you're in DC, I'm in DC, for the most part, our officers don't care what your immigration status is. Let's see, what are the ramifications of the current administration pursuing the deportation of Mahmoud Khalil, a lawful U.S. resident born in Syria and married to an American citizen, under a rarely used law that allows Secretary of State to remove non-citizens deemed a threat to the U.S. foreign policy? This is being challenged. The Alien Enemies Act, which I'm sure you guys have heard in the news so much lately, is a wartime act that has been used to detain citizens and non-citizens. I was about to say illegally, but I mean, it is, the Alien Enemies Act does exist. It's not an illegal act, but it is not completely legal to be using it when we are not actively at war. So the judge can agree or disagree with me on that. I tend to lean a little bit far to the left on this. So his attorneys are currently challenging whether or not it was lawful for him to not only be arrested the way that he was arrested, but for him to currently be in proceedings. And earlier, I did show you Mahmoud Khalil's notice to appear. In that notice to appear, it's supposed to be laid out exactly when he arrived in the United States and what he is alleged to have done to violate immigration law or the law in general. And it was not done. It was not done. It was not documented properly. He was not given sufficient notice to be able to admit or deny the allegations in that notice to appear. He has very good attorneys that are challenging all of that. So we're just watching to see what the outcome is going to be on that case. And I'll stop giving my editorial and opinion on that. But if you want to talk to me privately about it, I'll talk about it forever. Is updating a change? So somebody sent me two direct messages.
I think Akinyele also want to comment.
Yeah, I think I have to agree.
Oh, yes, sorry.
I agree with April that the notice to appear was not specific enough to be a proper notice for immigration court purposes. And I think also that there is a distinction, however, between Khalil, who's a green card holder, versus I think the young lady that was arrested this week from Tufts University. She's a visa holder. The question in that situation is whether or not the Secretary of State has the authority to revoke her visa sua sponte, and whether they can deport her directly without even appearing before an immigration judge. I've had situations before, even before this environment came about, when my client's visa was revoked. It was taken straight from Clayton County Jail, put on a plane, and sent back because he had some contraband on him, so I think in some situations, the Secretary of State has, I think, the authority that is slightly different. I think what they call it, the Foreign Policy Act, the alien that has, I think it says that if the Secretary of State has reasonable grounds that this person is doing something that is potentially adverse in the country, that they could deport them. I know that is probably going to end up in court as well. The Supreme Court will have to decide all those things, but that might be the only distinction that that I've seen in these two cases.
Thank you, sir. April, how do you obtain a G28?
A G28. So if you have an attorney on retainer who's representing you, they can give you a G28. It is a notice of representation. You both will go ahead and sign it, and then you will keep a copy in your email, and you can keep a physical copy on your body while you're traveling.
You have a direct message. Okay, I think.
Yeah, I have two direct messages. One is updating change of address still advisable under current circumstances of detention? I'm an officer of the court. I can't tell you don't change your address. You have to update your address as required by the court. Number two, do you have an opinion as to whether a non-immigrant visa holder that has the visa revoked still has to be presented before an immigration judge? I've had clients deported before upon visa revocation. So I think it really depends why the visa is being revoked. So the two cases that first come to mind for me is that I had a student whose visa was revoked because when he flew into the United States, he originally flew into New York where he was supposed to be going to school, and then he bought a separate flight to go out to California. And they, upon landing in California, revoked his visa because they said, oh, now you're showing intent that you're not really going to school in California, that you're not really going to school in New York. When the truth of the matter, which he could easily establish, was that he wanted to go visit some family in California very quickly before his school started. He still had like 2 weeks before school started. So of course we challenged that, and his visa was not found to be, it was reinstated. This person, what we're being told anyway, we're not a part of the case, but what we're being told is that she is having her visa revoked because of an op-ed that she wrote, not because she participated in any protest, not because she directly harmed anyone, but because of an op-ed that she wrote that they are interpreting to be in support of a terrorist organization. I think that requires judicial review. I don't think that should be a unilateral act. That's my opinion. I don't think that anyone is served well, citizen or non-citizen, by allowing the Secretary of State to be able to take this kind of unilateral action against people for exercising freedom of speech. And there's a whole debate about whether or not she gets to have freedom of speech because she's a non-citizen. Yes, she does. Everything I just said right there was my opinion.
There's a question in. Please, what's the fate of someone facing? Did you see that?
Okay. Please, what is the fate of someone who is facing an individual hearing very soon, but under defensive asylum, but having a spouse with a green card of 2 years old? Spouse is not a U.S. citizen yet. So you have some options. If you already have the I-130 filed, which is the first step in doing the spousal petition, then you can present that to the judge and ask for your case to be continued or administratively closed. Or if you have a strong asylum case, then you can go ahead with your asylum case, and if it's approved, then you adjust through asylum, get your green card through your asylum case. But I would obviously need to know a little bit more details about the strength of the asylum case and which judge that you're assigned to, which court you're in, because some states and some judges are different than others, before I would make any kind of recommendation on which path you might decide to go down. So you can schedule a consultation with us at the Nigerian Center. to discuss that in more detail.
April, have a theory with the president invoking this Enemies Act. I think that puts the country in a peacetime, in a war situation. And does that have correlation with citizenship, with military? If the president have an executive order that says this is a peace, this is a wartime of invasion, and there's a pathway. You see what I'm trying to make, the connection I'm trying to make? And there's a pathway for citizenship on the military service. With no conditions, with no duration, probably a year, with the only stipulation being the country has to be in active wartime, and the president says the country's been attacked. Is there a connection there?
So you think that there might be some kind of push to get more people to join the military in order to become citizens?
I'm just thinking that that invocation may have some unintended immigration benefit. Could it have some unintended immigration benefit if there is an executive, and judge can also chime in, if the president put an executive that say it determines the country's on the wall with invasion, and there is a pathway for military during active war times to get some form of citizenship or residency.
So, Benga, if I can on my end, I'm sorry. I know as legislators, we've actually talked about that. And I would say I can't speak for federal officials because, again, this is a federal matter. But on the state side, just working with federal officials, this is something that we have talked about, and that can be unintended. Yes. The answer is yes. Because it's happened before, and that's how many were able to gain citizenship. And we thought about that too, being as though he's currently put in a lot of executive orders, and just with things going on, Yemen and so much other situations, and it looks like many may have to join. So that is something that we are having conversations about, and it looks like that's going to open up that door.
Thank you, Honorable.
Mm-hmm. They could still chime in. I just wanted to talk from our perspective because that's something that we would have to also put in the statute too.
Well, if you are making the argument, if you're applying for citizenship and you make the argument that we are currently at war because the Alien Enemies Act was invoked, then you're conceding that it was proper for the Alien Enemies Act to be used against these children. Well, they're not children, but you know what I mean.
Again, I've not thought about it fully. It's a theory that is still forming. I just thought there might be some door that has been unintentionally, inadvertently open here, because if the law says this and the president invokes it, again, it's something to think about. You can all do your research, but it's something to really think about.
Right. I wanted to say something to Ms. Kazim very quickly too. Along with your advocacy for doctors and other professionals, you might also be able to point out that there are a lot of people here currently in the United States who have been approved for an EB-2 visa. They've been approved as a skilled worker, a highly educated person, but there is a long wait period between that approval and when they can apply for a green card because we don't have enough visas allocated in that category. So if we could get more visas in that category, then we could close that wait time for those people to be able to apply for residency.
Oh, that's a great point, April. I did not think of that actually, because that is something. So I would definitely notate that. April, if you can, I did send my email in the chat. If I could put it in there again, if you could just email me that so I have it word from word, so I can talk to my colleagues and even look into some statutes that we can put in place here in PA for something like that. I know, again, it's a far stretch because it's a federal matter. But thank you so much. You just put it again. But that is something that we can still look at as far as PA, because again, like you said, it may be a federal thing, but then in the states level, we can kind of put some things in that might leave some open-ended questions where a judge may say, well, technically PA has this in place, so we may not be able to just fully deport them out, or so forth. So I would definitely love to put something like that in place. Thank you, April.
We have Miss Ugo. You can unmute, please.
Hello, good afternoon. I have a question. So if you're a dual citizen, right? Like you have both American citizenship, like a Nigerian citizenship, and you want to travel back home, can I still travel with both of my passports, like leave the US with my American passport and use my Nigerian passport when I get there and use my American passport to come back? Or do I need to get a visa to go back home to my country?
So if your country requires you to use, this is for everyone. If your home country requires you to enter on your home country visa, then you have to follow their laws. Otherwise, you can obtain a visa. But if your home country, which most of them do, require you to enter on your passport that you have for that home country, then that's the law that you have to follow. You can't go over there and tell them people, I'm Nigerian, I have Nigerian passport, but I'm entering with my US passport. You can't tell people what to do.
And if I can chime into that, we actually contacted the State Department on this question, and we put their response on our social media. Under the State Department website, there is a language there called Travel for Dual Citizens with Dual Nationality. And it states that you are required to travel with your American passport and enter back into the States with your American passport. It did not say you are required to travel to another country and enter that country with the US passport. You leaving and coming out of the United States as a United States citizen has to be with a US passport. And this is on the State Department website, and we took their language. If you go to the Nigerian Center social media, we posted it there on Instagram, Twitter, LinkedIn, and Facebook and all of that. Oh, okay. There's one more question for you, and then we're going to close us out in the chat box, April.
All right. If a parent comes to the US through a tourist visa and they have an American child and leave back to Nigeria after 6 months, years later, both parents are banned from entering the US. Does this affect the child's passport renewal? The child has birthright citizenship and they will be able to obtain their passport and all rights of a citizen, regardless of any issues with their family members.
Okay. Oh, by the way, was that an answer? I'm sorry. Okay.
Yes,
Okay.
yes.
I was hearing, but I wasn't listening. I was moving the slides. Okay, that has been answered. Okay. We want to, at this point, please let us give a virtual round of applause for our esteemed, wonderful speakers for taking the time to speak with us and share this wealth of resources with us. We're eternally grateful for your service and for your support for our community. I just want to highlight and just make some announcement for those who just came in lately. This event is brought together by 3 organizations: Nigerian Center, NAPAC, Nigerian American Public Affairs Committee, as well as ANA, Nigerian organization in the state of Georgia. These are Nigerian American organization, not just serving Nigerians, but serving all immigrants in our communities. These are all local 501c3s. We are as powerful as a community to the degree we support our organizations to continue to do things like this. So any organizations you are able to support, please reach out and see how you can get involved in what we do, either as a volunteer, as a supporter, as a donor. We highly appreciate it. We are all 501c3s, tax deductible. NAPAC is not, but they also have NAPAC Foundation, which is 501c3. Yeah. So I want to highlight our upcoming events at the Nigerian Center. House Resolution 82 is a proposed legislation that is championed and introduced by New Jersey Congressman Chris Smith of District 4, advocating for the redesignation of Nigeria as a country of particular concern. Nigeria was previously designated under the Trump 1.0 administration was removed under Biden and now it's being reintroduced. There was a congressional hearing on this matter about 2 weeks ago. Nigerian Center is holding a community town hall to consider arguments for and against this designation. Please go to our website and register to be a part of this very important meeting. If you have not filed your taxes, as you have heard, tax filing for immigration purposes is considered good moral character. Attorney April, is that right? I wanted to ask you that question, Attorney April. Is filing your taxes regularly considered having good moral character for immigration purposes?
Yes, it is.
You heard it. So if you have back taxes, there is no excuse. Come to the Nigerian Center. It's a free service, regardless of your immigration status. You can do it in person and you can do it virtual. The website is nigeriancenter.org/VITA. VITA is the Volunteer Income Assistance Program of the IRS. All the preparers are IRS certified. They are volunteers, but they are all certified. Please take advantage of it. As you know, April 15 is the tax deadline. Someone put up their hands. I'll take it real quick. Perhaps it's related to what I'm saying. You can unmute, Mercy.
Yeah, thanks for letting me ask the question. And it's really not related to what you were saying, but it's a question regarding immigration.
It's not really. Can you just hold it real quick? Then I will promise to come back to
Sure.
you. And if I forget, please unmute and ask.
Okay.
Immigration and folks were chatting. How do they contact their attorneys? 2 ways you can do so. If you're in the Washington, D.C. metro area, you can walk into our office. That is the entrance to our office. You would see that signage there every Thursday from 12:30 to 4:30 for free of charge. You don't have to be citizens, and there is no income eligibility requirement to be served. Once you walk in, you will be served. If you're not able to come in, you are outside of the DMV area, you can put in a virtual consultation. There is a small fee associated with that to still get the same service. And you may not be able to get the G28 full representation. The clinic does provide partial limited representation, as Attorney April explained, including things like interview prep, full document review, a second opinion, even if you already have a lawyer or if you are in the current, so reach out to the Nigerian Center, assistance with completing immigration forms, interpreting requests for information and evidence. All of those things we're able to help you. And we pretty much cover the entire immigration path spectrum, from employment-based to family to humanitarian-based to SJIS, special juvenile status, to asylum, to all of that. As Attorney also mentioned, please go to our YouTube page. It's robust. There is a playlist there called Know Your Rights, and we've covered all of these topics in great detail. And after that, and should you still need resources to review your application before you put it in, feel free to reach out to the center. There's a fantastic organization called NALA, Nigerian American Lawyers Association. They also support the center as well. So we have a breadth of lawyers at the center. Volunteer opportunities available on our website. Please go to Nigerian Center /serve. Our community partners, if you're a nonprofit, social, faith-based, business, media, please join our community partners. But importantly, you don't have to have a title to be a Nigerian Center ambassadors. We don't personally know all the resources you saw on this event tonight. There are members of the community who have all these connections who support the center. You can also help in that capacity. And if you're not following us on social media, please do so. We are active on Facebook, Twitter, LinkedIn, and Instagram, and our YouTube page is highly recommended as well. Our handle is The Nigerian Center, and it's on platform Nigerian Center, one word. Finally, donation. Please, we ask that you consider supporting Nigerian Center as a donor. Becoming a recurring monthly donor is the best way to support Nigerian Center. And this could be donation of any amount, $5, $10, $20, whatever you can. This is a volunteer-led run organization. These are people taking time for their 9 to 5 to support their community, and you can support as well. Your funds is going to go a long way. And this is tax deductible. If you rather want to support, and we work nationwide, but our organizations partner are even more regional specific focused. In Georgia, in California, in different states, you can support ANOG, Nigerian organizations in Georgia. You can support NAPAC. They have PACs across the country, or you can support the Nigerian Center. That said, Mercy, I'm going to open up and you can ask your question.
Oh, okay. Thank you. Okay, looks like someone even answered my question on the chat. I just was
No, please,
asking.
that was me, Mercy, but please still ask your question for April so she
Okay,
can give you a more definite, yeah.
yeah, I was just asking just a personal question for me because my fiance he has a student visa. He's going to be coming in very soon, and we are planning to get married. But I kind of read somewhere on the internet that if someone comes in with a student visa, they have to wait a minimum of 3 months, 90 days, something like that, before getting married to a US citizen. Otherwise, they would kind of consider it a fraud and he could lose his student visa, something like that. So I just wanted to like find out if that's true or not.
He's coming in on a student visa or a fiance visa?
On a student visa.
Okay, so you can get married anytime. And when you decide to file the paperwork, that is when you're going to be moving, he's going to be moving from student status to pending seeking residency.
Oh, okay, got it. Thank you.
Yeah, so Mercy, just so you know, that's what I was saying to you the first time when you said how long. I was saying you can go ahead and get married, but if you felt like you wanted to be comfortable and you wanted to wait between 3 months to a year, you can, but you can at any time. It doesn't really matter.
Okay.
And
Okay,
April,
got it. Thank you.
April, is there a distinction between when they can marry and when they can submit an immigration application with the visitors with a visa application?
Yeah, you can submit your marriage spousal petition the day after you get married. There's no limitation on when you can do that. But when you do that, that means he's no longer a student anymore. He's no longer on a student visa. He can't travel freely on a student visa. He's moving into a different category of pending adjustment.
Got it. Okay. Thank you very much.
And just for anybody else in here who's listened to the question, the fiance visa is the one that has the 90-day limit. If you come in on a fiance visa, that's the one where you have to get married in within 90 days. That's why I asked if it was student visa or a fiance visa.
Yeah, it's a student visa.
Okay.
Yeah. It's just so you're saying that if we do get married and we start filing like to change his status, he doesn't have the freedom to travel
No.
out of it. Okay, got it. Okay.
And last question,
Okay.
April, should students be traveling under this climate in general?
I'm a lot more conservative, so I would say no. If you don't have any necessary thing that's happening that you need to travel for, then you should just stay where you are.
Does that include going to Mexico and Canada?
Yes.
Okay.
If something's not happening in Mexico or Canada that you need to be there for, then you can just go to New Orleans.
Okay. That's it.
And I second that because I've been telling people that. I second that with April for sure.
Okay, this is significantly outside of the time advertised, but thank you very much. Once again, let's give a virtual resounding round of applause to all our subject matter experts, Judge Akinyele, Captain April, Captain White, Attorney.
I like that, Captain April. I enjoyed that.
Okay, not Crystal, though. Not Crystal. And everyone that took time this Saturday afternoon, our wonderful partner organization, NAPAC and ANOG, thank you everyone for participating, and we'll be in touch via email. Bye for now.
Bye, and thank you again for having me.
Oh my God, Rep Kazim, what? I'm so sorry.
No, I'm just saying thank you all. Thank you.
Thank you so much, Rep Kazim.
Thank you.
Rep. Kazim, thank you so much as well. We appreciate it.
No problem.
Yes, ma'am.